Sprinkle. How you doing today?
I'm good. How are you?
I'm good. Happy to be here.
Yeah.
So, did you look at what? Oh, go away. Look, all these messages popping up now. Did you look at that yesterday's when Becky Hill pled guilty to the charges?
I know.
That's a mess.
No. That is a mess. What comes next?
Well, according to AI, because, a lot of things we do go to AI and say, well, what do you think is going to happen? And you know what? It goes down into the world and it looks at other things and it comes back and tells us what it thinks is going to happen. I actually agree with it this time. So her plea just reinforces Alex Murdaugh's appeal argument that her misconduct, compromised the integrity of his trial. But it does not automatically guarantee him a new trial. Murdaugh's defense argues that her proven lies and misconduct undermine the original conviction, which is a central point in this case before the South Carolina Supreme Court. Here's the reason why. The basis for the appeal, was also based on the county clerk and her attempts to influence the jury, and his lawyers claim she did that to gain attention and profit for her book. Absolutely, she's pled guilty to it now.
Of course, yeah, there's no more question about it.
That's right. She has recently pled guilty to multiple charges, including obstruction of justice and perjury. She admitted to lying under oath during the hearing when asked if she'd shown sealed court exhibits to the media. Absolutely, she did. She took them in the room, let them look at the sealed evidence. And I don't agree with her sentence that she got. It wasn't enough.
No, not for something like that.
Because
she ruined your career. She may not be able to get her, if she has a retirement account, who knows if that's affected. There's a lot of things that we may not know about as far as the full sentencing, the full repercussions of what she did.
Well, and that's another thing that wasn't even mentioned or talked about. But I think at the point that you are going to cost the county $500,000 or so because they got to retry this case, which means bring everybody back, Her admission of perjury and tampering is a significant point for the defense. Dick Harput, I say this wrong all the time, but Harputian or Harputian, we'll just call him Mr. Harp. If Becky admitted perjury herself in a jury tampering hearing held by the judge, what else could she have lied about? This challenges her overall credibility.
Absolutely.
Stance. Now, they think differently. State prosecutors argue that their investigation found no reliable evidence that Hill's actions actually influenced jury's verdict. The judge in Hill's recent guilty plea hearing indicated that her sentence would have been much harsher if actual jury tampering had been proven. But see, I disagree with that. Because at the point where she has pled guilty to perjury, she was the one that was running the jury, running the jury people. Oh, boy.
Yeah, I suppose jury tampering is probably hard to prove because they have to prove that her actions tainted the way they looked at the case and the way they decided on the case. So that's probably a little bit difficult to prove.
A lower court judge previously ruled that while Hill's comments were inappropriate, they did not affect the jury's decision enough to overturn the conviction. That decision is a piece to the ongoing appeal, which is now in the hands of the South Carolina Supreme Court, which will be heard on February the 11th. So, just kind of, I don't know. It's going to be I think it's a 50-50 chance at this point.
Yeah.
It's pretty bad.
His attorneys are going to push for it for sure.
Oh, yeah.
Without question, they will.
If that was my attorneys, I'd be pushing for it too. I'd be like, Look what she did. Look what she did. I didn't have a fair chance in hell. Look what she did.
But what convicted him, in my opinion, was that video placing him there at the time of their death. You can't dispute that. You can't throw that out. You can't make that unseen evidence. That alone placed him there at the time of their death. Now, maybe if that video had never surfaced, there might be a better chance.
Right. But you know what though, when SLED, okay, hang on a second. When SLED did their review of everything and saw where he actually was, and that his alibi didn't really fit, and that he was lying about that, whether they had the recording or not, they could prove that he was there. Remember?
Yeah.
So that's kind of, I mean, that's
GPS and everything else. Yeah.
right. So that's another
I mean,
thing.
there was a lot of circumstances that questioned his involvement. Just him having the housekeeper clean up, and the way that she found things, and you know, the way that he immediately said, "Oh, this has to do with my son's body." There was a lot of things that made him look guilty. But I think I should say maybe the video sealed it.
Yeah, that the case is really it's horrible, but it's kind of interesting.
Yeah.
When you look at the whole big picture, I think it's kind of
very unfortunate, because it's so unfortunate.
Yeah. Those people never deserve that. I mean, I don't care. I don't
care. Even Paul, the mistakes that he made on the boat crash and everything. I mean, even the kids that were involved in that said that they didn't want that for him. And if anybody can speak on that, those kids can.
I agree with that. Let's see if I can pull up this.
I mean, they were the ones that were involved in it all, and they were the ones that have a say in things. But what our opinion is doesn't really matter at the end of the day.
You're right.
You know, it's the victims, how they feel. And if they didn't want the poor boy dead, then you know, how can we, the public, quote unquote, want something terrible to happen to that kid? I mean, that kid was an alcoholic, plain and simple. Right. He was 19 years old, but he was an alcoholic.
Well, you know, it's kind of interesting. Yeah, when we listen to Dr. Phil talk about it, and then talk about how, you know, the father's an addict, the child's an addict, and he's over there kind of almost babysitting what his dad's doing. But that just brought a lot home, didn't it? Made you rethink about a lot of the things that happened in this case. That poor child, he may have been hard to deal with, and he was, you know, this, that, or the other. But look who his parent was, and look what he was living with at home. That just kind of, that really made a lot of. Oh, hang on.
And if his dad was that into the pills, his dad was moody. There was a lot of things that go on to pill addiction, other than just popping pills and making you kind of, you know, incoherent. Your attitude, your personality. A lot of things change, where that's going to affect everybody in the household.
Yes. I'm going to pull this up over here. Okay. Well, I mean, I don't know that I could have lived with Alex Murdaugh. And I mean, because, you know, their moods were extreme. When they're like that, they're extreme moods.
Oh, yeah.
Imagine how that was.
Oh, yeah, absolutely. That's what I'm saying. You know, it's not just like he pops a pill and life goes on as normal. No, the mood swings, the agitation, and the same thing with the drinking, you know. Paul drinking and then not drinking, then his mood swings and his emotional state. I mean, that house had to have been in an emotional upheaval 90% of the time. It had to have been.
I don't know how Maggie. Well, Maggie didn't stay there a lot. Remember, she went to the beach house all the time. So
yeah,
I mean, she didn't want to be around it. I'm sure.
Yeah, no, I'm sure not.
Dang. Oh, here's what I was looking for. I'm gonna pull this up.
Sometimes when you don't know what to do, you do nothing, and it's not because you don't care or because you're just avoiding the situation. You really don't know what to do, so you do nothing.
Especially, well, now what if, but you know, they tried several different things and it just never worked, and she may have just been so tired of it, you know? Yeah. She just may have been to that point. I mean,
I can't say that I blame her, you know, I can't say that I blame her a bit.
I don't blame her one bit either. Okay, let me get this brief it's dated 09/09/25 was when it was done. Okay. Very interesting stuff here. I mean, it's not only that he's complaining about. Is this it? But he's complaining about other things. Oh, there it is, right there. Okay, so here's what we're going to do. We are going to share the screen. Hang on just a second. I'm going to make sure. I don't know if this is going to work. I don't know how it's going to work, but we're going to give this a try. Oh, God. Share my screen. All right. It's going to be right here. Oh, it is going to show it. All right. Now, let's see.
Well, I think Alex was going to appeal regardless. You know, obviously he was appealing irregardless. This just adds another. This just adds another layer to it, you know.
Right. So what I'm going to do is we're going to bypass a lot of this statutory stuff. We're just going to go down to the meat of it, where he starts talking about the fact. Okay. This is going. Okay, people, stop that now. I think I'm going to make this. I'm going to leave this up there like that. I wish I would make it smaller. Oh, let's see. Maybe I can make this. Maybe just fill up the page. Oh, there we go.
There you go.
That way y'all can read along. Okay, so here we go. Now we're going to start looking at this. Okay, that's a little better, right? All right, now.
Yeah, that's good.
Okay.
I've got it on my TV so I can see it.
Okay, just remember you got to turn that sound all the way down.
Yeah, it's all the way down. It's all the way down.
Okay. See, we're doing so much better now that we got our earbuds and stuff to work.
Yeah, yeah, the TV's on. The TV, I always have the TV off, so, but I do have the earbuds in. So we're just working through the kinks. We're going to get there.
That's right.
That's okay. That's okay.
I leave that TV on downstairs for my dogs, too. There's no sound to it, but they lay there and watch it. This morning I got this little video because there was a dog that was squeezing this is on TikTok, and the dog was squeezing this little noise-making thing, and the other dog picks him up and throws him in the trash. Well, when the noise started going on, Jack looked at this, and he was following the little squeaky noise that was on the screen. They can see that. So they can...
I had a dog once who loved to watch animals. It didn't matter if it was a cow, a pig, a horse. He would literally sit and put his paws up and watch the animals for hours. It was hilarious. It didn't even have to have any sound. He just loved the animals.
Did he? And I'm sure he was caught too, like he thought he was.
Oh, he was glued to it. He was just glued to it. It was the cutest thing ever.
Oh, I love my baby dogs. All right, I guess we better start reading. Okay, so this is their reply statement of fact. It's a 35-page factual presentation. So, it is based on the prosecution is based upon the overwhelming evidence of guilt. It cannot withstand scrutiny. In fact, the case was built on an investigation. It says on investigative failures, fabricated evidence, and jury tampering. This is what they're saying on the other side. The state ignored exonerating evidence, misrepresented forensic findings, and relied on inflammatory but irrelevant financial evidence to distract from the absence of proof that Alex committed these murders. Really? I don't think they thought that the money is the reason. Wow.
Right.
Yeah, the evidence actually shows a contaminated crime scene with ignored alternative suspect evidence, fabricated blood splatter, testimony that the state abandoned when it was exposed, cell phone evidence that supports Alex's innocence, no credible motive for such extreme action, systematic jury tampering to ensure conviction, critical forensic evidence lost through investigative malpractice. I do agree with them that the crime scene was contaminated. That point
I do too.
Yeah. What do you think about the fact that they're saying about, let's see, the cell phone evidence? No, there was no cell phone evidence that supported his innocence.
Yeah, I was just thinking the same thing. Get out of my head. I was like, what is that? What are they talking about there? That's more like cell phone evidence that supports his guilt rather than supports his innocence.
They know right where he was based on where it came.
Right?
Isn't that funny? Get out of my head. Oh, Lord. And see, that's why we're a good team, because we think alike.
Yeah.
And, some people just don't like us, and that's okay, too. That's okay. Anyway, so the state's mischaracterization of a flawed investigation. A, the investigation was fundamentally compromised from the beginning. Contrary to the state's assertion, a thorough investigation, the evidence just demonstrates critical investigative failures that tainted the entire case. All right. Number 1, the crime scene contamination. First respondents trampled through the crime scene in the feed room, destroying potential evidence, including bloody footprints that may have belonged to the actual perpetrators. Okay. Number 2, failure to collect basic evidence. Flood crime scene forensic agents did not attempt to lift fingerprints from the feed room doors, doorknobs, or entrance areas where Paul was, his life was taken, a fundamental failure in any homicide investigation. Number 3, they ignored alternative suspects. Noticeable tire tracks in wet grass that did not match any Murdaugh vehicles were never followed or investigated, demonstrating investigative tunnel vision from the onset. Predetermined conclusions. SLED's chief investigator testified the conduct investigation concentrarily, but admitted that they never eliminated the appellant from their investigative circle and never included anyone else within it. Okay, so that was the first part here. Now, let's talk about that for a minute. Well, yeah, there was other tire tracks there. Remember what the housekeeper said? There was a closer.
The cleaner?
Yeah, the cleaner. Yeah. Remember what she said?
Yeah.
Mm-hmm. Maybe it's true. Maybe that's true.
Yeah, I don't feel like he was the only one involved. I can't say that I feel like I have any clue of who it was.
Right.
But I feel like there was more people. There was more people than just him. Because where did those guns go? Where did those guns go? Those guns were not on that. Those guns were not on that property. Those guns were off that property. But somebody had to remove those guns.
Mm-hmm. Mm-hmm. So where did they go in the hour that he waited before he called 911? Mm-hmm. So, what else did she say? What else did they say?
And he was so well known. Had he been driving, if he had left the property, he would have been driving fast. He would have been driving erratically. And he was so well known, somebody would have seen his vehicle on the streets, driving in those manners. He would have been seen. Yeah. Somebody else came and got those weapons.
Who do you think it was?
You know what? I don't even know.
There could be so many different
because I think he had a lot of shady acquaintances.
Mm-hmm.
I think he had a lot of people that he got himself involved in on different levels, that it could have been anybody.
Even that Fleming character that he conned into taking the money with him.
Yeah.
Yeah.
I've seen different interviews with him, mm-hmm. and I where he said, at one point he told him he was done being his errand boy and he was done with all this. I know he did some very unscrupulous things, but I tend to kind of believe him that there was a certain limit to what he was willing to do.
Okay. Well,
I don't know. That's just my personal opinion.
Okay.
But he very well could have been involved.
Well, after we look at this brief, that'll be the next part that we look at. We'll go ahead and look at him and review him for a minute to see if we agree on him or not. I mean, I've only seen one thing, and that was when he was being sentenced.
Mm-hmm.
So the next thing that they're complaining about is critical forensic evidence was lost or ignored. Number 1, DNA evidence. SLED identified DNA from an unknown male under Maggie's fingertips, but never submitted this potentially exonerating evidence to CODIS for comparison, a basic investigative protocol that could have identified the real perpetrator.
I don't think she ever came that close in contact with anybody.
Well, even if it was somebody else's, she could have. Listen, we know that she. The suspicion is that she was kind of seeing somebody else.
Yeah.
Okay. So I mean,
I don't think she never came in close contact with the person who killed her. Close enough for her to get his DNA or her DNA under her fingernails. I disagree with that one.
Right.
But it still should have been if there was that evidence, it still should have been investigated regardless. It still should happen.
I mean, and maybe it's not too late, you know? Maybe they can go back and tell us. Who knows? Number 2.
Yeah. Well, I'm sure they kept all that.
Oh, yeah. I just hope they don't have to dig them up and all that, because that is horrible. That is horrible.
Oh, that's awful. That's awful.
Number 2 was the cell phone location data. SLED's mishandling of Maggie's phone resulted in the overriding and permanent loss of location data from the night of the murders. The data could have definitely shown that Maggie's and Alex's phones were not traveling together, supporting his innocence. SLED's failure to use a basic Faraday bag or simply turn off the phone displays investigative malpractices. Now, I remember that her cell phone was not even with her. Wasn't it left in her vehicle?
They didn't, but they wouldn't have to be traveling together. That has nothing to do with anything. I don't understand that.
I don't understand that part either. Okay. So we'll go here and we'll move on down a little bit, and we're going to go to the next part, number 2. All right.
And we know where Maggie was. There was no question about where she was that night.
That's right. But, you know, they were trying to introduce this third party. Oh, we'll talk about that when we get to that. Okay. Because there's part of this over here, too. So the state's fabrication and misrepresentation of evidence, number 1, or A, the blood splatter fabrication. Now, the state's case was built on fabricated forensic evidence. Number 1, false grand jury testimony. The lead case agent made materially false statements to the grand jury, incorrectly testifying that SLED found loaded shotguns with buckshot, birdshot, and combinations at the residence that matched the combinations that shot and killed Paul, and that Alex's clothes contained high-velocity blood splatter, indicating that he was in close proximity to the murder. Okay. Number 2, we're going to come back.
But they found shells that matched. They found shells that matched on the property.
Right.
They found them in a bush but
yeah. We also saw a T-shirt that had the splatters on it, and he had residue on his clothing.
Yeah, and I had heard that, and then I also heard that was false, that was not true. So I don't know what to believe in that.
Okay, that's fair. Now, the next part that they
I'm not talking about on his hands. I'm talking about on his clothing.
Right. Yeah. See, that I don't know either. Because, I mean, you would not get that amount of transfer residue from bending over to see if they're breathing or whatever. But he was not.
No, you wouldn't.
He never even did that. So I don't know how he got it on him.
Well, and if he leaned over to turn over Paul, like he says that he went to turn him over and the cell phone fell out of his pocket, I'm surprised there wasn't an exchange of blood, because Paul was covered in blood.
Oh God! Yes.
So why was there not blood on his hands? If he touched that boy, he had to have touched blood.
Well, because remember, he went and took a shower.
Yeah.
Remember the water in the floor, and then the pajamas had been moved, and yeah.
Mm-hmm.
But I wonder if they even tested the shower for blood.
Probably not.
Maybe they'll tell us in here, so we'll see. Okay, so manufactured expert opinions. SLED flew to Oklahoma to pressure their blood splatter expert into changing his initial report that no blood splatter evidence. When SLED's own lab report definitely determined there was no human blood on Alex's shirt, the state abandoned this fabricated evidence rather than acknowledging their misconduct. Okay. Number 3, change theory mid-trial. Rather than admit the fabrication, the state simply shifted, arguing that Murdaugh changed his clothes after the murders, a theory unsupported by any evidence. Number B, questionable ballistics testimony. Here, I think this is where it talks about that now. The state's ballistics evidence lacks scientific foundation. Number 1, let me do this. Oh, I wish I could just scroll over here without having to do all this. Okay, here we go. I'm sure there's a way to do this, but I just don't know how to do it. But that's it. Number 1, the ballistics expert necessarily presumed, without any supporting test, studies, or data, that every .300 blackout manufacturer in the world makes singular, unique extraction marks, a claim that defies scientific mythology. Don't know about that. Number 2, direct connection. Notably, the SLED ballistics witnesses did not and could not offer an opinion that any of the specific weapons seized from Moselle were used to murder Paul and Maggie. All right. That's an interesting. Let me go back down here now. We'll go to number 3 in a minute. Okay. Now, we just talked.
But they did say that he had those kind of weapons, and those weapons were not found on the property. So where were they?
That's right. Where were they? But wasn't it weird that also Alex Cox used that same blackout weapon when he was shooting at what's her name?
Brandon. Yeah, Brandon.
Gabriel and Brandon. He used that same type. Wow, huh? So number 3. The state ignores exonerating evidence. A cell phone evidence actually supports innocence. The state mischaracterizes the cell phone evidence, which actually supports Alex's innocence. Number 1, Maggie's phone orientation change. While Alex was calling Maggie's phone, it registered an orientation change between 9:06:12 and 9:06:20 p.m. But Alex's phone was recording steps while Maggie's was not. Well, of course, it was sealed. The state's own phone forensics witnesses concealed he would expect to find steps on both phones if the same person possessed them. Oh, bullshit. They could have been left in the house or left in her car, and he could have still been called.
Mm-hmm. Right? Yeah. He didn't have to have it on his body. He could have had the phone, but had it elsewhere. I'm not carrying it with him. Absolutely.
So that I don't think that's going to hold water at all.
No, I don't think.
The defense expert testified that iPhones have a raise-to-wake feature that would illuminate the screen when picked up or thrown from a moving vehicle. Mine does not. It does not just turn on when I pick it up. If it's turned off...
Yeah, I think that has to be turned on.
Right. So that's not exactly true. Timing evidence. OnStar data shows Alex passed the location where Maggie's phone was found at 9:08:36, traveling 42 miles per hour, approximately 2 minutes after the last orientation change on her phone, making it impossible for him to have thrown it there. Okay. Unscientific rebuttal. The state's rebuttal evidence consisted of a deputy spending a weekend in his office tossing an iPhone of different models than Maggie's phone to see if it would illuminate, an unscientific and unreliable experiment that contradicted the defense's qualified expert's testimony that the raise-to-wake feature and the likelihood expert's testimony about that raise-to-wake feature and the likelihood that the orientation change would register on an iPhone when picked up or thrown from a vehicle traveling at 42 miles per hour. Okay, so I can see where that is not really a scientific, this thing is shaking, a scientific way to see if the phone comes on or goes off or what the screen is doing.
Right.
It's really based on what model iPhone you have. Okay, so
what model, if that feature's turned on, turned off, there's a lot of factors that go into it.
Right, so I think that's not really going to hold water either. All right. It's fun to pick it apart, isn't it?
Yeah. Well, that's, of course, they're going to bring up everything that they can to possibly get this going.
Right. Oh, I wish we could watch these oral arguments so much, but it's not an open courtroom. But since it's a high-profile case, I wonder if they're even going to try it. That would be interesting to watch. Okay.
Mm-hmm.
The Kittle video. Here we go. The Kittle video does not prove guilt. The state overstates the significance of the Kittle video. Normal family interaction. The video shows normal families going about their routine without any sign of trouble or hostility. Hardly evidence of an impending murder. Okay. But he lied about being there.
Yeah. Why lie?
Okay. Yeah. So limited time frame. The video only places Alex at the kennels from 8:44.49 to 8:45.47. Both Paul and Maggie's phones remained active and responsive until 8:49 p.m., indicating they were alive and unharmed after Alex left. That's what the state's evidence is saying. Acoustic evidence. Okay, here we go. Defense acoustic testing proved that a person inside the residence with the television on could not hear gunshots from the kennels, supporting Alex's account of not hearing shots while inside. Okay, don't know about that. All right, we weren't
I
there.
would think it would take him longer from 8:45 to 8:49 to get back up to the house. I don't think he would have been back into the house, sitting in front of the TV when the TV's on if the shootings did occur at 8:49. Because that was quite a ways. The kennels was quite a ways from the main house.
Right.
So he probably would have been on his way there or outside. So that really doesn't even apply.
But wait a minute. Remember, Maggie's leg was run over by one of those 4x4s. The tire marks was on it. Did he jump on that into the house and then run back down there? Because I
wonder if they tracked how long it took to get from the kennels to the house in the 4x.
Right. And we haven't seen the evidence on that. Okay. Then we're going to go to C. The state's mischaracterization of Alex's drive to Alameda. Okay, the state mischaracterizes Alex's drive to Alameda, falsely claiming that his speed of travel and where he parked when visiting his mother was suspicious. Number 1, speed of travel. The OnStar data shows that Alex does not stop en route to Alameda, his mother's residence, or on the return trip to Moselle. While at times he speeds, excessing the limit, going to and from Alameda, there was nothing to suggest that Alex's speed was unusual for him. In addition, the occasion when he increased speed was consistent with overtaking slower traffic on a two-lane country road. One could argue that speeding away from a murder scene is common. However, there would be no reason for someone who was speeding away from a murder scene to then race back to that same scene, as the state insinuates. Okay, we're going to move it down.
I don't have to agree with that part.
That's a little, I kind of agree with that too. Go to number 2. Okay. Now, number 2, parking spot at Alameda. The state also asked us that Alex parked at an unusual spot in the backyard of the residence, suggesting that he perhaps was hiding the murder weapons at the rear of the property. However, the uncontradicted testimony from all witnesses was that Alex parked in customary location for family members who were visiting Alameda that night. He parked near the back porch and entrance into the kitchen where Mrs. Murdaugh's bedroom was located. Alex's son Buster and brother John Marvin both testified that this is the preferred location when visiting at night, after Mrs. Murdaugh had gone into her bedroom with her sitter. Okay, that I don't know anything. I don't know about that. I wouldn't even know how to answer that. Okay, now we're going down to this part. Interesting stuff here. Now, the state's motive theory is unsupported speculation. A financial motive lacks credibility. The state's theory that Alex would murder his wife and son to distract from financial inquiries is implausible. Number 1, the routine legal matter, Alex's attorney in the boat case, Dawes Cook, testified that the upcoming motion hearing was routine and not especially concerning. Plaintiff's counsel Mark Hensley conceded nothing explosive was expected at the June 10th hearing. Number 2, there's no immediate There is no immediate threat. The confrontation with Jeannie Secretan, or Sickinger, I'm saying that wrong, but about the Ferris fees occurred in the afternoon. When Alex received the call about his father's hospitalization, Seckinger immediately ceased her inquiry and left his office sympathetic. Disappropriate response. The suggestion that someone would commit double murder to delay routine legal proceeding defies logic and human experience. The prosecutor's admission. During the closing arguments, when the defense argued the motive theory was unbelievable, the prosecutor responded that the jury could disregard their motive theory entirely and find Murdaugh guilty because the state is not required to prove motive, only malice, an admission that even the state recognized the weakness of their theory. Extensive financial evidence was irrelevant and prejudicial. The state presented 6 days of testimony about financial crimes involving 25 victims and over $9 million, none of which had been suspected at the time of the murders. This evidence served only to inflame the jury against Alex that proves he committed the murder. Let me move this down. Now that's kind of interesting, isn't it? Okay, going back to over here. All right. There. Then it says, okay. So I'll read the extension yet. The absence of physical evidence supporting guilt. A. Forensic evidence does not support the state's theory. No blood evidence, despite the state's claim that Paul's killer would have been covered in blood and brain matter. Trigger warning, I'm so sorry. From the devastating headshot that blew open his skull and caused his brain. Oh my God, I'm so sorry. Trigger warning. That caused his brain to hit the ceiling. That's how bad it was, to be honest. I mean, that's how bad it really was.
Can you imagine?
Can you imagine seeing your child like that? Hell no. Alex had no visible blood on his clothing or person when law enforcement arrived. His clothing appeared to be fresh and clean, as if he had just come from the laundry. But it did. Even the housekeeper said it was not. His shirt was not ironed, and that she ironed his t-shirts. And can you imagine? Number 2, minimal gunshot residue. Only 2 particles of gunshot residue were found on Alex's hands. 3 on his shirt and 3 on his shorts. None on his shoes, and 1 on his vehicle seat. The buckle, consistent with handling the shotgun he retrieved for protection after discovering the bodies. Wait a minute. Ding, ding, ding. Wait a minute. How is he going to get residue from a gun? He went and grabbed some gun. We heard him talk about that. If the gun had not been shot, then how does he have residue?
Right.
Hello. I'm going to question that one right. Yeah. Number 3. DNA evidence from Alex's clothes revealed. Let me scroll down now. Revealed no significant amount of Paul or Maggie's DNA, and only trace amounts consistent with touching the bodies to check for signs of life. Okay. B. Missing evidence points to other perpetrators. Unknown DNA. The unidentified male DNA under Maggie's fingernails was never submitted to CODIS. Number 2. Tire tracks. Tire tracks at the scene did not match Murdaugh's vehicle and were never investigated. And then we get to the big one. Jury tampering. This one down. Okay. So then it goes to jury tampering. And this undermines the verdict. Systematic interference by court officials. The conviction was obtained through jury tampering by then Fulton County Clerk Rebecca Hill. Financial motive. Hill publishes a book about the trial titled Behind the Doors of Justice, and repeatedly stated during proceedings that a guilty verdict would sell more books because she needed a lake house. She pled guilty to this, folks. She pled guilty to saying direct jury interference. Multiple jurors came forward to describe Hill's efforts to influence their deliberations, including entering jury rooms after the state rested and telling them not to let the defense throw you all off, distract you or mislead you, and not to be fooled by Alex's testimony in his own defense. That is kind of damaging. Think about it.
Yeah, she should have never said that. That's wrong. I have to agree there.
Yeah. We know that these jury members said, "Oh, well, we didn't pay any attention." But didn't they not pay attention, or did they pay attention? Because it could have been lingering in their mind, whether they realized it or not.
It's all subliminal.
Right. Predetermined outcome. Hill began planning to write her book before the trial began, demonstrating her financial interest in obtaining a conviction. Now that is suspicious, okay? B. Compromised deliberations. The jury's deliberation, less than 1 hour according to jury interviews, suggests that systematic tampering was effective in preventing fair consideration of the evidence after 6 weeks of testimony. Well, they did come to an agreement in 3 hours. Now,
yeah, it was fast.
To me, that seems like they had all made up their mind before they ever went back there.
Oh, yeah.
Okay, so move on down a little bit more. Additional evidence of investigative failures, inadequate search procedures, limited property search. Although Alex was at the center of this investigation, Flood did not search his mother's residence and property at Alameda for the murder weapons or any other evidence. Number 2, cursory investigations. Flood agents only conducted a cursory search at Moselle, which did not reveal any evidence linking Alex to the murders. Number B, public safety misrepresentation. On June 8, 2021, Flood and the Colleton County Sheriff's Department issued a joint press release stating that the public did not have any reason to be concerned. Now that is inflammatory, don't you think?
Mm-hmm.
Yeah. For their safety, despite having no suspect in custody or having failed to conduct a thorough investigation for alternative perpetrators. Number 7, conclusion. Alex Murdaugh's conviction resulted from a perfect storm of investigative incompetence, prosecutorial misconduct, and court official corruption, not from reliable evidence of guilt beyond a reasonable doubt. The state's characterization of overwhelming evidence of guilt is simply not credible. Okay. And then it's going to go into the argument. There was their basis right there. And now they're going to argue their points. Okay. This is where it gets fun and juicy. Not that any of this is juicy, but you find a lot of things in these appeals that you never really knew because you weren't in the courtroom. Clerk of the court, Becky Hill's deliberate jury tampering denied Murdaugh his right to a fair trial before an impartial jury. The practice of law is a qualitative, not quantitative endeavor. How many cases a lawyer cites is of little importance. What matters is that the cited cases say. Likewise, the number of pages in legal briefs is of no significance compared to the quality of the argument. In this case, the state's brief cites 176 cases and is 163 pages long with 12-point type and about 60,000 words, approaching the length of the PhD dissertation. Oh boy. Now, that's kind of interesting. Despite all the make weight and the most important issue in this appeal, clerk of the court Becky Hill's jury tampering. The state's brief fails at its very first sentence. Becky Hill's improper comments did not affect the outcome of this case. This is a speculative answer to the wrong question. The constitutional right at issue is not any right at correct outcomes. This issue is whether Murdaugh received a fair trial. A defendant is entitled to a fair trial, but not a perpetrator. Okay, so what I'm doing just to explain is I'm not there's a lot of little things like that I'm not going to read right here. See all these where they're stating the cases and the pages. I'm not reading all that, so we're just going to skip on down to the next part here. Okay, so I got to move past. To safeguard these rights, it's required that the jury render its verdict free from outside influences of whatever kind in nature. There is no overwhelming evidence, exception to the right to a fair trial. Let's see, move on down a little bit. Okay, so then it moves on down to what the evidence was against him. Oh, wait a minute, I skipped. Let me get back up here and I skipped one. Holding failure to give a reasonable doubt instruction is not harmless, no matter how conclusive the evidence. Okay, and then it says Tooney versus whatever. Reversing convictions because no matter what the evidence was against him, the accused had the right to have an impartial judge. If a man committed a murder at the 50-yard line during the Clemson, South Carolina football game with 100,000 eyewitnesses and a million watching live on television with a video recording of the crime as it happened, and with all imaginable direct forensic evidence immediately collected and preserved, that man would still have the right to a fair trial. Now, how silly to use a football. I don't like
right.
That. But we know that, they're all big into that, so I guess I understand. Now, wow. Okay, it goes, at a minimum, this would require the man to have right to a trial without any elected official advocating the guilt of the accused in the jury room during the trial for her own personal profit. Goes on down, it goes, There was this private communication of the court official to members of the jury, an occurrence which cannot be tolerated if the sanctity of the jury system is to be maintained. A new trial must be granted unless it clearly appears that the subject matter of the communication was harmless and could not have affected the verdict. And if so, surely the same applies in a circumstantial case like this one, where there is no eyewitness, where there is no video of the crime, where there were no murder weapons were recovered, and where no forensic evidence directly connects the accused to the crime. Before replying to the state's arguments regarding jury tampering, Murdaugh must correct one issue in the state's factual recitation regarding the jury tampering hearing. The recitation ends with a claim that the trial court's written order entered after the evidentiary hearing implicitly rejects Juror Z and Juror 741's claims that Hill said not be fooled by the evidence presented by Murdaugh's attorneys. After Jury Z claims that Hill said deliberation shouldn't take long. See that? I'm sorry, but that is kind of damning. Well, the deliberation shouldn't take long. That's kind of damning. I'm sorry. Oh wow. So we're going to come on down to right here now. Okay. So and then it goes. The trial court did not implicitly make factual findings in the state's favor in the state drafted written order. Its order says what it says and does not say what it does not say. Oh, wow. It does not say that Mrs. Hill never said what Juror Z or Juror 741 testified that she did. In fact, it says Juror C testified under oath that Mrs. Hill told them not to be fooled by the evidence presented in Murdaugh's defense, and that Jury 741 testified Mrs. Hill said that the deliberation shouldn't take long. The only controverting evidence in the record is Mrs. Hill's denial. However, the trial court found Mrs. Hill was not credible as a witness. Mrs. Hill has since been indicted for perjury regarding her testimony at the evidentiary hearing. I'm not going to read the indictment. It would be an abuse of discretion to credit the denial of a non-credible, self-interested perjurer accused of wrongdoing over the disinterested testimony of jurors with nothing to gain from the proceedings and who were only involved in it because they were randomly selected for jury service. The trial court did not so abuse its discretion because it never made such an implicit finding. Well, now that's a mouthful, isn't it? Mm-hmm. I'm going to have to say, we can talk about this right now. I'm going to have to say it was a little damning. It was damning for her to say these things. Because
that should have never been said.
Right. If I'm a juror and I'm sitting there and I'm nervous wreck anyway, and this is a bunch of things going on all at once, and I'm scared because, oh boy, you want me to make a decision as to whether one of the most prominent people in this city or this county is guilty of taking his wife and his son's life? Me? I don't even know anything about law. Imagine how they're feeling, and they've got to be up against this, and then they have her over there just, oh, it's okay. It's not going to take long. You got this, blah, blah. Yeah. And I'm not being favorable to Murdaugh. I'm just saying in general, that is tampering as far as I'm concerned. Okay. A. Prejudice from a state official's jury tampering cannot require proof of an actual effect on deliberations. The state's first argument is that to cause prejudice, improper communications must actually affect the jury's deliberation. That is wrong. The only possible evidence to what actually affected the jurors' deliberations would be the jurors' testimony about their deliberations. They are hopefully the only witnesses to that, and it's not permissible to ask about their deliberations. That's true too. A juror may not testify as to any matters or statements occurring during the course of the jury deliberations or the effect of anything upon that or any other juror's mind or emotions as influencing the juror to assent to or to dissent from the verdict. That's a mouthful. Indeed, it would be odd for the U.S. Supreme Court to ever speak of a presumption of prejudice or any presumptions about external influences if one could just ask the jurors how external influences affected their deliberations. Okay, let me roll this down for you. I think I'm down here at rule. Okay. Oh, look at me. Put you back up here. Rule 606B continues an old rule that entered our common law through a case of alleged juror misconduct, which applied a now disregarded doctrine that a witness testifying to his own turpitude could not be credited. Okay. Then it goes, it has been universally retained in the context of the jury deliberations long after the discard of the doctrine because it serves as an important purpose. We do not ask the jurors to separate one external influence on their thoughts months after the verdict from everything presented to them during the trial, from what they heard from the other jurors during deliberations, and from everything they heard from any source since the verdict was rendered, and instead the inquiry to determine that was said and that to apply to any object's analysis regarding its probable effect on a hypothetical average jury. God, that's a lot to say. Oh my goodness. A lot of rules here, huh? Let me see. I'll go back down a little bit further because I'm not going to state all of those. Let's see. Basically, we're going down to the court likewise applied an objective standard in State versus Kelly, where jurors in a capital case allegedly were exposed. Hey, Leslie, how you doing? Oh, you know what, Leslie? We jumped on. I forgot to put the thing out there. I'm so sorry. It's my fault. Because, I'm going to take a break for a second anyway. Because I went on and did a little short. I don't know if you saw it about Sebastian. Some people got upset with me, and I discussed with Sprinkle and said, oh, we're going to go ahead and do that 2 o'clock thing about the appeal. And so it's my fault that you did not get a notice. I'm so sorry. It's okay. I'm sorry. I will take the blame for that. But I'm glad to see you today. So what we're going over is the appeal that was filed in the Murdaugh case. And it's juicy and it's interesting. So here we go. Oh, you did? Oh, you saw it? Let me ask you something, Leslie. Do you think I was being fair? I mean, it made me cry a little bit. I'll be honest with you. I did cry a little bit. It still makes me cry a little bit because it's so hurtful. It's just so hurtful, all of it. It is. So, all right. Here we go. So, the court likewise applied an objective standard in the State versus Kelly, where jurors in a capital case allegedly were exposed during the trial to a pamphlet. Yeah, I do think you were fair. Oh, thank you, Leslie, because, I kind of felt bad for a minute, but I was like, oh, okay. So so in this one case, they were given this pamphlet. All right, what has the pamphlet got to do with it? So a trial should consider factors like the number of jurors exposed to the weight of the evidence properly before the jury, and the likelihood that the curative measures were effective in reducing the prejudice. Kelly does not suggest one would instead just ask the jurors how the external influences affected them. Moreover, these Kelly factors are not an exclusive list of factors to consider. At a minimum, a court must also consider what was said and who said it. Okay, I agree with that. The statement from an official with authority over a jury beyond questions carries great weight. It does carry a great weight, because they're relying on her to tell them what they need to be doing, right? They ask her questions. Okay. And applying this objective standard to determine whether improper communications affected the jury's deliberations and thereby its verdict, the state's BR 48, I'm not going to read all of that, presumption that comments by state officials to jurors on merits of the matter before the jury are prejudicial. Where such comments are proven, the state must demonstrate that they were very harmless, which is nearly impossible. And it is impossible because you cannot ask the jurors certain questions. Okay, so Murdaugh's position, with which the state disagrees, is that the weight of this evidence properly before the jury cannot, as a matter of law, outweigh deliberate jury tampering by an elected state official exercising legal authority over the jurors who attempted to cause a guilty verdict so she could personally profit from it. Let's see. Possibly prejudicial between jurors and an officer in charge are absolutely forbidden and invalidate the verdict, at least unless there's harmlessness is made to appear. But how do they know that harmlessness was made to appear? Think about that. How do we know what was harmless? We don't. Now, back over here. So then it goes, to be sure. Oh, wait a minute. I was leaving off a whole section, wasn't I? I'm sorry. Okay, so then it comes down. It cannot be tolerated if the sanctity of the jury system is to be maintained. The disagreement in the crux of the issue on appeal regarding Mrs. Hill's jury tip, Murdaugh's position is that, okay, so that outlays, we read that. Okay. What's that? I hear it chirping.
That's my dog with a stupid toy. I'm sorry.
It's okay. It's all right. I was like, oh, no, I don't want to have that problem anyway. Okay, so to be sure, asking whether an external influence would probably affect a hypothetical average juror is a method of determining whether improper external influences affected the verdict. The state's error is slipping the adverb actually into that language. We can never determine what actually affected the verdict. Instead, we determine whether some external influence actually happened, and that whether it would likely affect the hypothetical jury's verdict. The answer to that question is never proof of what actually happened in the jury room. The answer is always if presumptions about what might happen in a hypothetical jury room, a presumption of prejudice, the absence of prejudice. Okay, I know that's a mouthful, but okay, we'll move this down some. I just think that they have some very valid points here. The next part is the trial court was required to presume prejudice. The Fourth Circuit has provided a summary. Oh, come on, people need to quit texting me and everything else. The trial court was required to presume prejudice. The Fourth Circuit has provided a summary of Maddox and Reamer upon which Murdaugh cannot improve. Okay, it is a this is kind of weird. It is a fundamental that every litigant who is entitled to a trial by jury is entitled to an impartial jury, free to further extent practicable from extraneous influences that may subvert the fact-finding process. Because an impartial jury is obviously the touchstone of a fair trial, it talks about footnotes, etc. Courts throughout modern history have labored to safeguard sitting jurors from improper contacts and advances by third parties. In an earlier instance of this recurring problems, the Supreme Court adopted the rule that unauthorized communications to jurors are forbidden unless determined to have been harmless, and that requires the court to order a new trial, Maddox versus the United States, goes on with that, where the court directed that private communications to jurors during a trial should be deemed presumptively prejudicial. With that burden, a rebuttal resting heavily on the party supporting the jury's verdict. Okay, and then it goes on to say, okay, and that establishes that the requirement of a post-trial evidentiary hearing in which the prevailing party has the opportunity and burden of rebutting the presumption of the jury's prejudice. Oh boy, what a mouthful. Okay, I'm down for this for a minute. Now, it goes with footnotes. All right, I'm going to go to this page. Okay, so then he says, Haley versus Blue Ridge, let's talk about those things. And it is clearly established federal law. And this court lacks authority to construe later Supreme Court cases as overruling its implication. Later cases, however, clarified that a presumption of prejudice does not apply where the communications issues were innocuous, meaning they did not touch the merits of the case before the jury. Mrs. Hill's comments were about the weight or the meaning of the evidence presented in the trial, thus touched the merits of the case before the jury. The trial court found her conduct to be intentional and motivated by personal financial gain. Okay. Both the trial court and the state failed to cite single reported cases in any jurisdiction in which deliberate jury tampering by a state official in a criminal trial was held to be harmless and non-prejudicial. Prejudicial. I'm sorry. Y'all heard me, prejudice, right? Instead, the state attempts to open the door for court to be first to ever take this extraordinary step with two arguments. And here's the arguments. First, the state argues that Rimmer expresses a rule of federal criminal procedure, not constitutional law. Rimmer found that presumption of prejudice in Maddox and Wheaton, whatever in all those numbers, found the presumption in Maddox and all the numbers, in turn relied on state court cases and all the numbers. I'm sorry, that's the way to put it. Those cases could not be based in federal procedure at all. Certainly not the federal rules of criminal procedure first adopted in 1944. Rather, they express a fundamental principle of law, constitutionally codified through language like due process and impartial jury. Tracing the presumption of prejudice from ex parte communications with the jury about the merits of this case to Lord Delamar's and then the case. This is number 2 of their thought. The state argues that the court has never applied Rimmer presumption in support. It veers off point to argue that South Carolina does not have Rimmer hearings. We have Aldred hearings. And start citing those cases. Aldred hearings concern premature jury deliberation. Well, okay, even if it's premature jury deliberation, so they've already proved that happened because they were only back there an hour and they'd already decided, he was guilty. They all thought about this before they ever even went back there. So either way, it's both wrong. Okay, that's just my thought on it. I'm sorry. So he goes, let's see, there's all those numbers. He goes, this issue is that the knowledge of the witnesses and other jurors prior, not actions of the external state actor attempted to influence the jury. But the state's point is irrelevant since an evidentiary hearing was in fact held in this case. Wherever whatever the nomenclature, I'm sorry guys, let me look at this. The nomenclature, the nomenclature, I don't know what that word is, but anyway. I need to get my other glasses too. These are, okay.
That's a lot of reading.
Yeah, it is. As to the state's argument that Rimmer does not apply in South Carolina, Murdaugh stands on his own opening brief at pages 40 to 43. Rimmer is controlling the U.S. Supreme Court authority to this court must follow and has never rejected. I don't know what that word is. I don't know what that word is. Kind of silly, huh? All right, calm down. Read the second part. Oh, I skipped a bunch, didn't I? Okay, now read that part. Okay, read C. All right, here we go. I'm gonna lose myself. Over here. I'm sorry. All right. Jury tampering by an elected. No, we didn't read that part, did we? No. By an elected official in charge of the jury for her own personal profit. Okay. The state complains Murdaugh's argument that the presumption of prejudice is irrebuttable when a state official tampers with a jury during the criminal trial. About the merits of the case is a novel claim. The facts of the case are admittedly novel. She wrote a novel. Think about this. To undersigned counsel's knowledge, this has never happened before. In some cases, the defendants have bribed or intimidated jurors. In some cases, low-level bailiffs have made offhand comments like guilty or the judge does not like a hung jury. You shouldn't say that either. In some case law enforcement has engaged in investigative activities and properly influenced jurors. That's happened too. But Mrs. Hill's deliberate tampering in favor of a guilty verdict to promote her own book sales is surely unprecedented. I believe that's true. It is unprecedented. I mean, it's so wild that she actually admitted to it. I wonder why she admitted to it. The other day when we were talking about this, I said, y'all think maybe she did that because she wanted him to get a new trial? Well, I mean, I know that sounded crazy. Like, what do you mean? What are you talking about? Maybe she could make money. Did somebody pay her off to make her interfere so he could get a new trial because they knew he was going to be found guilty? I don't know.
You never know.
The particular facts of this case make the presumption of prejudice irrebuttable. Prejudice could be rebutted by showing that the comments advocated acquittal or that no deliberation jury was exposed to Mrs. Hill's tampering. then it says, improper influence was removed prior to deliberations. But because Ms. Hill did in fact tamper with deliberating jurors by making comments advocating conviction, the presumption of prejudice cannot be rebutted. A hypothetical reasonable jury, hearing from the elected official who administered their oath, she does the oath, okay, to the jurors. You see what I'm saying? Like, she's the one that gives them their oath that they're going to tell the truth, blah, blah. And then she's over there making these statements. Wow. So, as an oath that they should not be fooled by the defense would likely be prejudiced against the defendant as a result. The jury then would not be an impartial jury. In a fair trial, the jury is impartial, and elected state officials do not engage in the jury in secret They do not engage the jury in secret ex parte advocacy for guilty verdicts. Where that happens, the trial is not fair, and the defendant is prejudiced. The only way to rebut that conclusion would be to create exception to the defendant's right to a fair trial by saying that does not matter whether the defendant received a fair trial, because the outcome of a fair trial would have been the same. But the Constitution does not allow exceptions to the right to a fair trial before an impartial jury. The state then proceeds to complain Murdaugh's reading of Cameron is literalistic. Constitution, statutes, and cases mean that they say they should be interpreted based on the precise words used. Further, Murdaugh has never argued Cameron's use of the phrase subject matter means that the content of the communication to a jury does not matter. The subject matter is a category or description of the content, which can be determined only by examining the content. Oh my God.
Oh, wow.
It's a lot, but it's interesting. The state's contention that absent of showing actual juror bias, there is no structural error. It's completely unsupported by the citation Smith versus Phillip. Smith dealt with the question of whether a bias should be implied regarding a juror who had applied for a job in the prosecutor's office. The portion of Smith the state cites deals with implying the juror bias from employment relationships with government or from publicly surrounding trials, not deliberate jury tampering. Oh gosh. The U.S. Supreme Court, let me bring y'all down with me. Y'all got to go on down with me now, it's a lot. We're all the way down here, aren't we? The U.S. Supreme Court, right there. Okay. The U.S. Supreme Court case with the greatest factual similarity to this case is Parker, in which a new trial was required because a bailiff told a deliberating juror that the defendant was guilty. As the state correctly notes, there was no mention in Parker of any presumption to rebut. Indeed, in Parker, the state conclusively proved the bailiff's comments did not affect the actual result because the votes of the jurors who heard the bailiff's comments were not needed to convict. Nevertheless, the Supreme Court reversed the Supreme Court of Oregon, which had held the comment was harmless, because in any event, the petitioner was entitled to be tried by 12, not 9 or even 10 impartial, unprejudiced jurors. The error in Parker was structural and prejudice was irrebuttable, just as it is here. Yeah. Well, I mean, let's stop. We'll talk about it for just a minute. Okay. I kind of agree. I know a lot of people are not going to agree with me. I know my thought's going to be like, oh no, why are you saying that? It's going to cost a lot of money. But the thing is, if she's the person that gave them their oath to follow the rules, to follow the law, to follow the charging documents, to look at only the evidence as to make their decision. If she's the one that's given them that oath, but then she's turning around and saying, well, it won't take y'all long, That's just like telling them, well, you're going to vote he's guilty anyway. What do you think, Sprinkle?
Yeah, I mean, a lot of her comments, if she did say those things, which obviously she did because she pled guilty, they were things that should not have been said. They should not have been said.
So the first court that he appealed to denied it, said, oh, it didn't really matter. I think that the Supreme Court's going to have they're going to have a little different take on it, right? Okay. So then we are down to, we read the U.S. Supreme Court. The state did not rebut any presumption or prejudice. The trial court improperly examined jurors about their deliberation in this case. Now, that's kind of true because they asked them if anything that was said to them made any difference on whether they voted guilty or not guilty, which you cannot do that. Okay. The importance of the prohibition against jury testimony about jury deliberations is codified in Rule 606B of South Carolina Rules of Evidence. It's discussed above in the appellant's opening brief at pages 64 to 70. In reply to State Murdaugh merely states that Rule 606B provides, upon inquiry into the validity of a verdict or indictment, a juror may not testify as to any matter of the statements occurring during the course of the jury's deliberations or to the effect of anything upon that or any dissent from the verdict or indictment or concerning the juror's mental processes in connection therewith, except that a jury may testify on the question whether extraneous prejudicial information was improperly brought to the jury's attention or whether any outside influence was improperly brought to bear upon any juror. Yet, despite this rule, the trial court asked each juror, was your verdict influenced in any way by the communications of the clerk of this court? Ooh. I asked you previously, was your verdict on March 2nd, 2023, influenced in any way by the communications from Becky Hill, the clerk of the court? You answered that question, yes. See, a couple of them said yes. Yep, here we go. These are the things we didn't know, right? Obviously, the trial court asked the juror about the effect of Mrs. Hill's statements upon that. Other jurors' minds and emotions as influencing jurors to assent or dissent from that verdict in violation of Rule 606B. There is no colorable argument to the contrary, notwithstanding that many pages of the state's brief devoted to this issue. The state's assertion that the only time Justice Toll inquired, which is the judge, inquired into the deliberation process was in response to improper 606B material introduced by the appellant, State Bar Block. It was mistaken because the trial court asked each juror whether Mrs. Hill influenced his or her mind to assent or dissent from the verdict. The state's assertion that the Green decision allowed these improper questions is mistaken because Rule 606B issue was expressly not before the court in Green State versus Green Block. Having asked the inappropriate questions, the trial court awkwardly found that the only juror who gave an answer favorable to the defense was not credible when reporting her own mental process. Oh God, are we victim blaming the juror now? Wow. Even though she was not alleged to have any bias in favor of Murdaugh, she voted to convict him of all, an order denying a new trial, to allow the prohibited question to be asked of each juror, and then to disregard the answer of only juror to give an answer favoring Murdaugh. Okay, so everybody else said no, but she said yes. So it's like it didn't really matter. Okay, that's really not fair. It has to be unanimous, right? Just like their verdict has to be unanimous. Well, in Texas, it has to be unanimous. I know there are states where it only takes half of them or 3/4 of them or something like that. But I don't know what state that applies to. Okay. So then it goes, let's see. To allow the prohibited question to be asked of each juror, okay, and then to disregard the answers only because only the one would allow a reasonable observer to question whether justice has been done in this case. The trial court abused its discretion in not crediting jurors Z's account of her own mental process because there was no evidence disputing her testimony. The trial court abused its discretion when denying a motion for a new trial where its decision was based on factual findings. But the record is in all respects void of evidence to support juror Z did not contradict herself. There is no contradiction in being both influenced by Mrs. Hill's comments and pressured by other jurors in deliberation. Okay, I can see that happening. And I don't know if you ever served on a jury or not. But you get back there and we're on page 29. Oh, I've read a lot. Yeah. You get back there and people are like, we've been here for weeks. Okay, we're tired. We want to go home. You can just imagine all the statements that are being made back there. And you're the only one holding out. What are you doing? I mean, you can imagine that happening. And then Becky Hill over here saying, well, it wasn't supposed to take y'all very long anyway. You know you did it. Or whatever she said. That she'd made a decision. So I can see where this juror did feel pressure. I absolutely did. So, right or wrong, that's just how I kind of see it. But the court should avoid that issue, and an amateur psychoanalysis of the state offers for jury Z. Instead, the court should apply Rule 606B and simply engage in objective analysis of whether statements to jurors should watch his body language when Murdaugh testified. What? That is, his testimony would be an epic day. Oh my God, no, you can't be saying these things. Wow. Okay. Shit, that's bad. That his testimony would be an epic day. The jurors should watch him closely when he testifies. That they should not let him throw you all off. That they should not allow him to distract or mislead you. And that you should not be fooled by his attorney. Would likely affect a hypothetical reasonable jury. Absolutely, I think it would. Absolutely. The inevitable outcome of the analysis is that those statements would influence any reasonable juror. I'm sorry, but I have to agree with it.
Yeah, I do too.
This is bad. I did not expect it to be this bad. The record in this case conclusively demonstrates Mrs. Hill's comments prejudices Murdaugh's right to a fair trial. Nevertheless, fighting the obvious, the state dutifully argues that Murdaugh was not prejudiced by Mrs. Hill's instructions to the jury to disbelieve his own testimony in his own defense. The state's argument that he was not prejudiced because 9 of the 12 jurors did not hear Mrs. Hill's comments is foreclosed by Parker. In any event, petitioner was entitled to be tried by 12, not 9 or even 10 impartial or unprejudicial jurors. The state argues some of her comments were not as egregious as the comments in Maddox or Parker, the other 2 cases. But some clearly were, like telling jurors not to allow Murdaugh's testimony in his own defense to distract you or mislead you, and telling them not to be fooled by it. That's god-awful. Regarding the latter statements, the state argues Justice Toll found the comment never happened, but she made no such finding, which she state admits by earlier describing this finding as implicit. The only comment the trial court made regarding the fooled statement was footnote 3 of the order denying this new trial, which is in recitation of Mrs. Hill's testimony. Clerk Hill was asked by the state if she told jurors not to be fooled by the evidence presented by defendant Murdaugh, to look at his movements, and that deliberation shouldn't take long. She denied each allegation. The order denying a new trial, the trial court found Mrs. Hill's testimony not to be credible. Her only comment at the conclusion of the evidentiary hearing regarding Juror Z's testimony was that her testimony about the effect of Mrs. Hill's comments on her vote was ambivalent. Okay. The trial court's later order found that Juror Z credible on every point addressed except for her statement that her verdict was affected by comments from Mrs. Hill. And then they denied a new trial. So this was the first time they appealed it, and it was denied. To any reasonable person, admissions, I'm sorry, God. To any reasonable person, admissions, okay, I'm not even saying it right now, from a senior, what is that word? Say it for me. Hang on.
I lost where you're at.
Right here, this word here. What is that word?
Hold on, I can't.
Admonishments.
Admonishments?
Admonishments. Thank you. Thank you so much. Okay. My God. All right.
That's a lot to say.
From a senior court official to disbelieve a defendant's testimony immediately before he testifies in his own defense is more prejudicial than a bailiff's conclusory expression of his own personal belief in the guilt of a defendant. And the state's advice to the court not read too much into Parker is almost comical. Parker is the seminal case incorporating the Sixth Amendment against the states through the 14th. We believe that the statements of the bailiff to the jurors are controlled by the command of the Sixth Amendment, made applicable to the states through due process clause of the 14th Amendment. The state then moves again to argue overwhelming evidence, exceptions to the right of a fair trial, which has been addressed thoroughly above in the appellant's opening brief. Inter alia, pages 48 through 55. Jury tampering is prejudicial. It denies accused a fair trial. as Justice Scalia and Ginsburg agreed, and even a court certainly reached the right result. The violation of the right to a fair trial, tantamount to a directed verdict of guilty, would be per se reversible no matter how overwhelming the unfavorable evidence, because the very premise of structural error review that even convictions reflecting the right result are reversed for the sake of protecting the basic right, which is a fair trial. And of course, the evidence in the circumstantial, move you down. Oh boy.
I don't know if you saw what I typed in chat, but this makes me wonder how many other times she has done something like this.
You know what? That's a very good question, because I had the same thought. Get out of my mind, as you always tell me.
Get out of my head. Get out of my head.
I think that too.
Yeah. Because if this is her behavior, I would be willing to bet this is her behavior along just a baseline of her behavior. So she's probably had other trials that she's been a part of where she was prejudiced one way or the other way, and has probably made little snarky comments along the way. I wonder if that's going to open up any other cases to where this is going to be an issue.
You know what? Well, if they win this appeal and they get a new trial, every other lawyer who knows of something like this will absolutely file a new appeal. Yeah. Well, she's no longer.
Look at how, like, these not crime scene investigators, the people that work in the labs where they have tainted the evidence, where it has opened up hundreds of trials to where they mismarked evidence, they've done this, they've done that. And I don't remember, there was one several years ago where it was a big, huge situation where that crime scene tech tainted hundreds and hundreds of trials once they opened up the investigation. I wonder if it's going to become something like that.
Yeah, I'm sure. Well, she can never hold office again, and she
never
retired, and she wrote this book. And for some reason, I think that part of her deal about getting a low sentence was taking the funds from the book and donating it to something. I'll have to double check.
Wow.
I think I remember that yesterday as like, okay, if you do this, we'll do that kind of a thing.
Yeah.
I got to scroll this down, don't I? Let me scroll this down.
Yeah, I mean, this does not look good. Of course, we're just reading one side of it, but this doesn't look good.
But I mean, they're telling us exactly what happened here. And she pled guilty. Now that she's actually pled guilty, this makes me think, what can they argue? What can they say? She pled guilty.
Yeah.
It's out there now.
They can just say that it really didn't influence the jurors' decisions.
Well, they can't. They've already asked them, and that was improper too, according to Rule 606B.
Yeah.
It's a cluster F, you know that? It's just a big cluster F now. And of course, the evidence in the circumstantial case is far from overwhelming. There were no witnesses to the murder, no murder weapons were recovered, and no DNA or blood evidence links Murdaugh to the murder. There's evidence of at least one person other than Murdaugh participating in the murder. And what do you mean other than? Are you saying he participated?
Right, that was a poor choice of words.
That was, Reversing convictions of a man accused of murdering his wife and children after 2 trials, who was acquitted on the 3rd trial, where the first 2 convictions were overturned due to the admission of the prejudicial character evidence and unreliable expert testimony, the lack of forensic evidence linking the accused to the murders, and the intentionally unidentified male DNA found on the murdered wife. Oh my, boy, oh boy. And yes, that's true. I mean, they've already said they didn't test it, so. All right. The trial court allowed the state to introduce improper character evidence and other irrelevant and unfairly prejudicial evidence that they so infected the trial with unfairness as to make the resulting conviction a denial of due process. The state misapprehends Murdaugh's cumulative error argument. Okay. She goes, wait, if only 2 jurors heard her, why didn't they replace them with other. See, I want to know that too. I mean, did they find out about this afterwards? And that's the part I'd like to know myself. But if two jurors heard her say this, and they were still part of the deliberations, then they were tainted. In my mind. But who am I? I'm just a person reading an appeal over here. Ooh. The state argues that Murdaugh did not spend enough. I'm sorry. The state misapprehends Murdaugh's cumulative error argument. The state argues that Murdaugh did not spend enough pages on the cumulative error issue presented as the issue on the appeal, and that argued on page 71 to 73 of his opening brief. The state again views briefing as a quantitative exercise in which the length of an argument or the number of cases cited means more than the content of the argument. Murdaugh's cumulative error argument is short because of its simple. Murdaugh argues that the aggression of errors extensively discussed on pages 73 to 119 of Murdaugh's brief collectively violated Murdaugh's right to due process of law because they rendered his defense far less persuasive than it might have otherwise been, and the trial court consistently enforced the rules of evidence, citing Chamber versus Mississippi and other cases. The state attempts to distinguish Chambers on its facts, but Murdaugh only cites Chambers for the legal standard that multiple errors can combine to deny in a trial court with traditional and fundamental standards due process. A rule expressly stated that the conclusion of the opinion. More importantly, the state entirely misapprehends this argument. This is not the cumulative error doctrines described in South Carolina appellate cases like State versus Becky. The cumulative error doctrine provides relief to a party when a combination of errors, insignificant by themselves, has the effect of preventing the party from receiving a fair trial, and the cumulative effect of the errors affects the outcome of the trial. Murdaugh does not argue that the assigned evidentiary errors are harmless when viewed individually, but reversible errors only when viewed collectively, an argument which must be made in the first instance before the circuit court, state versus whoever. Murdaugh argues that each assigned error is reversible on its own, which is why he cites states versus crime and all the things that go with that. For the proposition that these evidentiary errors were standing alone, reversible errors because they were substantial errors affecting the result of the trial. Murdaugh argues that collectively, the errors are reversible not only as evidentiary grounds, but also as constitutional grounds. This is an argument for the possible future federal litigation. Well, I'm sure this will be in federal litigation. How much you want to bet? Oh boy. You know who's let me get over here to a lot. You know whose appeal I really want to see? And that's Letitia Stouch's appeal. I want to see that so bad.
Oh yeah. Oh yeah.
It's sealed, and that makes me sick. I even wrote, well, this is how bad I am. I am kind of bad. I even wrote to that court and asked them, what makes her be allowed to seal her appeal, but not other people?
Right? Why is that allowed?
Because her victim was a minor.
Oh, well.
Right.
I mean, if it's done to protect Gannon, then okay.
Right.
Then I get that. I mean, that little boy needs to be protected as much as he can in death because he certainly wasn't protected in life. So I can't really balk too much about that.
Yeah. I mean,
but I just can't imagine it would have that much information in it that would be, I don't want to say, the only word I can think of is derogatory towards Gannon. Unless it talks about the murder itself.
It does.
Who knows?
It's going to talk about that. It's going to talk about her reasons. It's going to talk about what he did to her. It's going to talk about, those kind of things. Because she has always made him be a victim. And that's what these scumbags do. They're victims always. It's their fault. Because, again, they're sociopaths, psychopaths. And they don't feel like we feel. They don't have any empathy. They don't have any sympathy. They're just, he deserved it. Another day. Ugh.
Well, after what happened with his autopsy pictures, I can see it being sealed, honestly.
Right. Well, I can too. And I'm glad they did it.
Because that debacle with, the other creator over his autopsy pictures, that was just horrendous. That was horrendous.
I am so glad Stephen Stearns went ahead and took a plea for the same reasons, because that poor little girl would have been victimized again with that shit put out everywhere, because everybody would have.
You know she would have. You know she would have.
And
Although, I would have liked him to say that he was to admit to killing her.
Oh yeah, I would too. I just don't like the way he answered that. But either way, he's still in jail for the rest of his life.
Yeah.
So, and when you take a plea deal, it affects your appeals. So anyway.
Oh yeah, when you take a plea deal, a lot of times, because like Chris Watts isn't entitled to a plea.
Right. Because he took
not a plea, not a plea, an appeal. Sorry.
An appeal, right?
I said the wrong word. Yeah. So I think it all depends on how it's all laid out.
Right. I mean, I think different states have different rules. I mean, I'm not sure.
Yeah.
But okay.
Yeah, definitely. Leslie, rest in peace, Maddie. Bless her heart. That was one of the worst cases of child sexual abuse I think we'll ever see in our life. I really do.
And he is extremely mentally ill, because in his mind he really thought like, well, we loved each other.
Yeah, and he still talks like that. He's a freak.
He is a creep. If he ever gets into, well, just like, Murdaugh is in protective custody as well. And, so is Stephen Stearns over there. If he gets out into the normal population, those people in there will hurt him.
Oh, yeah, without question.
Because
without question.
Yeah. All right.
And deserved. And deserved.
Yeah, that's prison justice for you.
Yeah.
All right. So,
especially somebody who's in there for life and has nothing to lose. What are they going to lose? What are they going to do? Like they say, what, you're going to give me another life sentence? I'm already in here for life. What the heck?
Yeah,
what does it matter?
You're going to give me the death penalty? No.
Yeah, and they already have the death penalty. You know what I mean? It's like they have nothing to lose.
That's right. That's right. Okay, we're on page 34, guys. A little bit more to go here. It's not too bad. Evidence of financial crimes should have been excluded under Rule 404 and 403 of the South Carolina Rules of Evidence. This issue is not procedurally barred. The state contends the appellate waived its objection to financial crimes evidence by failing to appeal the trial court's alternative ruling, admitting that the evidence was res geste. Okay, that's a hard word. Res geste. The state's assertions are incorrect. Appellant objected to the financial crimes evidence in the trial court and has appealed the trial court's decision to admit this evidence. There has not been any waiver of the appellant's objection to the admissions. Yes, Leslie, prison justice. To the admissions of this evidence under any theory. And it goes State versus Johnson on that one. Okay. An objection to the admissibility of the evidence preserved the issue of whether the challenged evidence was res geste. Okay. In addition, the appellant appealed the trial court's decision to admit evidence of financial crimes dating back to 2015 on the grounds that such evidence is inadmissible character evidence, which is precluded by Rule 404. Evidence of a person's character or trait of character is not admissible for the purposes of proving actions in conformity therewith on a particular occasion. Rule 404b provides evidence of other crimes, wrongs, or acts is not admissible to prove that the character of a person in order to show an action in conformity therewith. The trial court's ruling that Rule 404 does not preclude evidence of prior financial crimes is squarely before the court. Irrespective of whether the trial judge reasoned that the financial crimes or evidence was admissible as motive, res geste, or both motive. Okay, it says res geste. Furthermore, the appellant argued in the trial court, argues in his brief that the financial crimes evidence should have been excluded under 4043, South Carolina, blah, blah, on the grounds that even if relevant and offered for the purpose of other than to prove Murdaugh's character, the financial crimes evidence was unfairly prejudicial. This argument applies equally to the evidence admitted under one of the exceptions listed in Rule 404b or admitted under the res geste theory. They keep using this word.
Yeah.
Lastly, The law of case doctrine is not absolute and does not apply if the decision was clearly erroneous and would work and manifest injustice. The lower court's rest to stay analysis is clearly erroneous. For bad act evidence to be admitted, under the theory, I'm just going to say the theory, there must be temporal proximity between the other bad acts and the charged offense. Okay? In Johnson, this court ruled that the temporal proximity had been met whether the evidence adduced at the trial established an unbroken 13-hour timeline of violence. What? Here the lower court admitted the evidence of financial crimes which took place 6 years prior to the charged offenses. Furthermore, during argument, the trial court reasoned that the evidence of this extensive financial crimes over such a long period was relevant to show the appellant's state of mind that he knew the scope of his undisclosed criminal behavior and the consequences of getting caught. The trial court further clarified that the ruling was not limited to the June 7 confrontation, but encompassed all financial crimes that may likely have led to a motive or lent itself to the motives for the crimes committed. Okay? Those remote financial crimes are clearly not temporally connected to the June 7 date. Confrontations and could not possibly be evidence pertaining to these murders. Okay. The state's motives, let's come on, I'm going to put this in here for you. It's actually fun reading this. I enjoy it. I know you're going, God, it's a lot of talking, but I actually do enjoy it. But I like reading, I like reading to people. To me, it's fun. Okay. The state's motive theory remains illogical and unsupported by the evidence. The state's motive theory that Murdaugh killed his wife and son to distract from impeding financial exposure suffers fundamentally from logical flaws that the state's brief cannot cure. There's a temporal disconnect with the financial crimes and the evidence of the murders. There is no evidence that Maggie or Paul posed a threat to disclose such evidence. The state's own evidence established that the Ferris fee, or the investigation being conducted by Steckinger, I think that's her name, was a one-off transaction, totally different from the extensive scheme perpetrated by the appellant to steal the client's settlement funds through the fake forged accounts. The Ferris matter under investigation was limited to whether the appellant received attorney's fees from the settlement personally rather than depositing the fees into the firm. Furthermore, the state's own evidence establishes that the Steckinger suspended her inquiry when she learned of Randolph Murdaugh's hospitalization. There was simply no need for Murdaugh to manufacture sympathy. His father's impending death would have been sufficient. Moreover, Steckinger was not investigating and had absolutely no suspicions that the appellant had been stealing client funds. Steckinger stumbled across this fake forged transaction months later, in September 2021, which led to the discovery of extensive client theft dating back to 2015. In addition, there was simply nothing on the horizon during the week of June 7 that remotely supports the state's manufactured motive thereof gathering the storm involving an upcoming motion hearing in the civil boating accident case. The state's own witness and attorney for the plaintiff suing Murdaugh admitted that there was nothing explosive that was expected to occur in that discovery motions hearing in the boating accident that was scheduled for June the 10th. Murdaugh's counsel in the boating case, which is Dawes Cooks, explains that the financial discovery being sought from appellant in this case was fairly routine and were appellant's objections to the discovery. Okay. Then he says, Cook further observed that the civil defense team did not have any concern about the upcoming hearing to compel disclosures of financial information. Cook also described the case as negligent parenting. Oh, Lord. A case premised upon an untested legal theory and that the state case was very defensible. Wow. Listen to what they're saying. Well, they were just going to chart. It was negligent parenting? Just negligent parenting. Okay. Lastly,
there's more to it than that. There is more to it than that.
There is more to it than that. Boy, now I've got to dig into that. Of course, it doesn't matter because it never.
I mean, I do tend to agree on the negligent parenting to a certain amount because they did allow that child to drink. They drank with him. There was a lot of things that played into that.
Right, it certainly was. I mean, we can't dig into it too much because since the death, nothing ever happened, and then they just They just sued the
Right.
estate, whatever. But what's wild about the whole thing is learning that the family was paid by the store who sold him the alcohol. They got nothing from the Murdaugh family.
I know. And that's a shame.
It is a shame. Okay. Lastly, unlike the cases cited by the state, neither Maggie nor Paul posed any threat of exposing Appellate's financial crimes. The victims were not witnesses, investigators, or obstacles to continued concealment. Instead, the murders actually increased scrutiny on Murdaugh rather than deflecting in the state's theory. It requires the jury to believe that the appellant chose the most extreme and attention-generating response to relatively manageable financial pressures. That makes it sound too simple because it was not manageable. It was way bigger than that. The case relied upon the states are factually inopposite. Inopposite. And involved fundamentally different circumstances. The victim was actively threatening to expose the defendant's crimes to the law enforcement. I think he wanted the life insurance money. Right. I think so too. Well, he had to keep funding the situation. He had to find new ways to get money. He drained all he could out of the legal firm, stealing from his clients. So now he had to find a new way to get money. The victim was the direct source of funds being stolen and posed as the immediate threat of discovery. The defendant stood to gain financially through life insurance proceeds. There you go. Here, by contrast, the murders eliminated no witnesses and removed no obstacles to discovery of Appellate's financial crimes. The state attempted to distinguish West Virginia versus McGinnis, which rejected an identical sympathy and distraction motive theory and is unconvincing. All right, McGinnis. Wow. You guessed it, Leslie. You were so right. Right there and then, insurance money.
Wasn't it only like 700,000 or was it more?
I think it was like 533,000 or some small.
Yeah, for some reason I thought it was like 783,000 or something. It wasn't like millions that I remember right, but I could be wrong.
Yeah, but Buster ended up with his mother's life insurance.
Oh, he did.
Yeah. The extensive presentation of financial crimes evidence created substantial undue prejudice. The state's true purpose and the actual effect of presenting 10 witnesses over 6 days detailing financial crimes spanning nearly a decade and involving over $9 million was to persuade the jury that no one really knew the real Alex Murdaugh, and that he is a person who hurts those closest to him without remorse, and that he led a double life for 15 or more years, lying, cheating, stealing, and he is a person who lies to clients, lies to his law partners, has mastered the art of persuasion with jurors by turning on tears when needed. The purpose and effect of this evidence was not to put the murders in a context as required under, the rest, we're going to say the rest, and to prove motive. This is the unfair prejudice that resulted from the state's extensive presentation of financial crimes. While the trial court provided limiting instructions, these cannot cure the fundamental problem. The extensive financial crimes evidence serves primarily to inflame the jury rather than illuminate any genuine motive. The state's own closing argument demonstrates that at this point, prosecution essentially abandoned the motive theory and told jurors it could be disregarded because the state didn't need to prove. The state need only prove malice. Okay. In State versus James, this court ruled that the probative value of admitting into evidence 7 prior convictions for burglary outweighed the very great potential for prejudice, regardless the judge's limiting instructions to the contrary. Here the state was permitted to introduce evidence of at least 38 transactions involving more than 25 victims, where the appellant stole at least $9,971 and I can't even say it. Oh my God. Almost $9,800. Almost $9,800. Jesus Christ. No, I've not been drinking today, guys. Okay, from his client and his law firm. And it gets this other long string to look at. The state also was permitted to introduce Murdaugh's confession of judgment provided to the Satterfield plaintiffs and the disbursement order from the South Carolina Supreme Court. No limiting instructions can cure the overwhelming potential prejudice through this avalanche of financial crimes and evidence presented over the 6 days. Murdaugh did not waive his objection to the financial crimes evidence. The state incorrectly suggests that the appellant's testimony to financial crimes constitutes a waiver of his evidentiary objections. The position contradicts well-established law that the defendants do not waive objections when they are compelled to address improperly admitted evidence to mount an effective defense. As clearly stated in Rogers v. State, error is not waived when the evidence is brought in later in an effort to meet or rebut, destroy, deny, or explain the improperly admitted evidence, similarly in State v. Logan. The court held that the defendant does not waive an error by attempting to minimize or explain improperly admitted evidence. It would be unfair to permit the state to introduce evidence, albeit later found to be inadmissible, but not to permit the defamation upon pain and waiver to attempt to meet it, explain it, or rebut it, or deny it. My eyes are all dried out now. Listen, this is so creepy. Okay, so I have my contacts on, right? One is for distance and one is for up close. But the problem is, once it starts getting dark at a certain time during the day, I put my glasses on to be able to read. It's so crazy.
Hey, I just Googled this. There was no life insurance on Paul or Maggie.
Well, then what was the problem?
Alex had a $10 million policy on himself.
Okay.
That when he tried to quote unquote commit suicide,
right,
that he was hoping Buster would collect. But everything that I'm reading here said that there was absolutely no life insurance on Paul or Maggie. And I thought I had heard something different, but that's apparently not true. It says even Alex himself said that there was no insurance policies on Paul or Maggie.
Well, I wonder what money I know he got some kind of money from her estate, so I thought it was the insurance.
Maybe it was from the estate, but yeah, there was no life insurance policy.
Okay.
Interesting, huh?
It is interesting, huh? Well, so then they can't even use the word insurance because there was no insurance. So there you go. Yeah, you think about
which I find that like weird. Like he wouldn't have he insured himself for $10 million, but he wouldn't insure his wife. I could possibly see not having it on your children. Right. But I mean, not them as wealthy as they were. You would think they'd have it on their children, but to not have life insurance on her is really weird.
It is, isn't it? I guess because she wasn't a breadwinner. I mean, I don't know.
Maybe.
I don't know, but I'm gonna skip past a couple of these because it's kind of like this. It keeps talking about this same old thing. But there's some question and answers down here that I do want to ask about.
It says Buster will receive $538,000 from the $2.7 million from the boat crash.
Boat crash.
So he got it from the boat crash. It says the boat crash killed 19-year-old woman Mallory Beach. The bulk of the proceeds, about 2.7, will go to Beach's family, as well as 2 survivors of the crash, the newspaper said. Another boat crash survivor will receive $100,000, while Buster Murdaugh will receive $530,000.
Wow.
And then it says Murdaugh estate sells for $3.9 million.
But he owed so much money to all these different people.
Mm-hmm.
Let's read these question and answers because I skipped past them because they're just talking about the same old thing. So rise to wait.
Sorry, I always run us off in the ditch. I'm sorry.
No, it's okay because
you know how I am. I always run us off in the ditch.
It's okay. We were thinking that, but we were thinking wrong.
To quote Dr. Phil.
So then they start going on and they start talking about the phone after all that. And it says, it starts talking about this rise to wait feature, and they have some questions and answers. Have you ever done this? Anything like this before? You ever mentioned testifying 6 times before? Did you ever, or was this your expert testimony in any case? So this is about this expert witness or expert testimony about this damn phone, right? And so he goes, My expert testimony in other cases was always about cell phone reports and the data contained therein. I've never actually done a physical experimentation and came up with a realistic result. I still don't believe that this result was realistic myself. So he goes, so your previous experience was extracting data from cell phones, which is what, they do, right? Correct. Is that what you're trained in? Yes, sir. The training that was listed in the extract data from the cell phone? Yes, sir. Are you an engineer? No, sir. Do you have any certificate in engineering? No, sir. Do you have any degree in academic qualifications in engineering? No, sir. Have you ever worked as an engineer? No, sir. You're trained in extracting data from cell phones. Correct. And when it comes to testing it around and seeing it how it moves, you don't know anything more anything else, do you? He goes, no, sir. So you have this. And then Mr. Barber goes, Your Honor, based on the previous answers, I would move to strike the expert's opinion. I would too, because he's not an expert. He's not an engineer, right? So, yeah, that's not going to fly. Let me see what else is, down here. Okay, let's go back down to page 55, because this is where the next interesting stuff comes in. There's just so much to this. I mean, geez. Okay, see where it says, talks about, okay, this is where the good stuff starts right here. All right, here we go. The trial court abused its discretion in admitting preposterous testimony that an unqualified law enforcement officer simply invented a state's request to rebut unfavorable evidence unexpectedly produced by General Motors during the trial. Oh no, that's interesting. All right. The state agrees that out of court experiments may be admissible if made under conditions substantially similar to those prevailing at the time of the occurrence. Oh, this is hogwash. The state could have offered a substantially similar out-of-court experiment to rebut Mr. Sturgis's testimony from this phone moving vehicle, from the phone being out of the moving vehicle and the picking it up and it turning on. That's what they're kind of talking about over here.
Yeah.
But, it's just crazy. Maggie Murdaugh's phone was thrown and then conducted the same type of data download and was conducted on the phone to learn whether the screen came on. Conducting this sort of data download in the area in which Sergeant McNeil was offered and admitted as an expert. But for some reason, the state decided not to do that. The state could have just thrown the phone in Sergeant McGinnis's office and then conducted a download of the document, whether the screen came on or not. But for some reason, the state decided not to do that. The state could have had video recorded the phone being thrown into the office so we could all see what he said he saw, just as the state routinely does with any witness that's interviewed. But for some reason, the state decided not to do that. The state could have had another person or a witness of the phone being thrown into the office to corroborate his testimony. But for some reason, the state decided not to do that. The state could have thrown a phone in the courtroom for the jury to see the defense and whether the screen came on or not. This is wild. With all due respect, Sergeant McGinnis and the prosecution, his evidence has every appearance of being fabrication. Rule 702 of the South Carolina Rules of Evidence, under the State versus Counsel and similar cases, precisely to keep this sort of garbage away from a jury. We have respectfully enforced the requirements of the trial court's exercise and their gatekeeping responsibility in admitting expert testimony. No, I'm telling you that is not expert testimony, and I don't believe that at all. In fact, I don't like it, and I'm not going to continue to read it because it's garbage the way they go on about it. Oh my Lord.
Yeah, I agree.
Okay, then he goes down to allowing SLED's firearm examiner to provide irrelevant, unreliable. Okay, well, what is this about? Let's go down to the firearms, because then we'll be done. We're almost done with it. Okay, because it's only like 60 pages or 62 pages, and we're on page 58. But I want to know what the hell they're talking about as far as the firearms go. I thought they were trained in this. I thought they had experts in firearms. I thought that they had.
Yeah.
Yeah.
You would think so. That's weird.
The state's response fundamentally misunderstands the gatekeeping role required under Rule 702. The state argues that because firearms identification has been widely accepted and used since the early 1900s, this alone satisfies the reliability standards. The argument conflates historical acceptance with scientific validity, a distinction the Supreme Court explicitly rejected and it states the case, all right? The state's reliance of State versus Hackett actually undermines its position. Hackett predates modern and scientific reliability and its standards by decades and reflects the now rejected general acceptance test. The council explicitly moved beyond. The fact that the courts routinely admitted this evidence before counsel is precisely why counsel established a more rigorous scientific reliability requirement. The state's citation to various jurisdictional accepting firearms identification evidence ignores that the decisions predate and inadequately address the fundamental scientific critiques raised by the National Academy of Science and the President's Council of Advisors on Science and Technology. Wow. So you're telling me that the state tried to use old information on firearms in this case? It did not even use the most. That's frightening, isn't it? Mm-hmm. The state emphasizes SLED's accreditation and verification procedures, arguing that these constitute adequately quality control and counsel. However, quality control procedures cannot remedy fundamental methodology and invalidity. God dang. Having two examiners reach the same subjective, unvalidated conclusion does not make that conclusion scientifically reliable. It merely compounds the error. The state's argument is an analogous to claiming that having two astrologers agree on a horoscope makes astrology scientifically valid. The council factors require quality control.
Oh, wow.
This is wild, isn't it? Scientifically valid methods, not quality control and invalidness. The state dismisses the NAS and PCST reports by claiming that they have been largely rejected as undermining admissibility and suggesting that these authors just lack the firearms experience. These arguments are both factually incorrect and legally irrelevant. Wow. Listen, we're going to it says, third, both reports identified the same fundamental problems. No empirical validation of the uniqueness assumption, purely subjective decision making without objective criteria, no established error rate, and circular reasoning of AFTE's sufficient agreement standard. Okay, listen. I think their brief is really good. I really think it's very good. It's a great argument. And I think, I'm going to stop reading for right now, but then it starts talking about this gunshot residue and some stuff, and there's some questions and answers. But listen, based on what we've heard already, Becky Hill, you have caused potentially a new trial to have to be for them to spend the money on a new trial. And you know what? It's very possible that the next court or the next set of jurors might find him not guilty. And when that happens, we have a big problem, don't we? Oh, I need to quit sharing my screen. Yeah. Because I think that he's actually guilty. And it's not just, it's based on what we've seen and what we've heard. But also, when you think about I don't know, let me ask you this, sprinkled on it. His premises, why would he do this? Why did he do this? Was it, if they had no issue.
The only thing I can come up with is because he knew the House of Cards was, as far as Maggie's concerned, he knew the House of Cards was falling, and he wanted to save himself the embarrassment of what was going to happen. Now, why he would kill his son, that I can't even come up with anything.
No. There's some...
I can't come up with anything as far as killing Paul. Unless he had to kill Paul because Paul saw him kill Maggie. Because he could have went down there and shot Maggie, and Paul could have been in the feed area, and he didn't see him. And then when he realized Paul saw him, then he had to kill him.
Mm-hmm. But remember them talking about, Dr. Phil talking about, Paul's over there having to gatekeep his father about the drugs and having to talk, basically telling on Alex, to the mother, telling her that, I found a bag of drugs, I found about, that whole thing, he's supposed to be quitting and all that. I wonder if it had something to do with that, because, addicts will just do anything. They won't mix fix, so, man, crazy.
Yeah, Paul could have threatened to go to somebody else with the drugs, if Paul knew, then of course Buster probably knew.
Oh, right. Well, We need to watch Buster's interview. Why don't we watch Buster's interview tomorrow? Because in Buster's interview, he starts talking about the dynamics in the family and the drug use and the alcohol use. It's a very good interview.
Yeah.
It took him a long time to come out and actually talk about it, but I was glad he did because it helps you understand the dynamics in the household. But when the housekeeper says that's what I knew he did it, well, I mean, she knows them best. So.
Oh, yeah.
That's what I think. I don't know. But let me tell y'all something. Sprinkle and I kind of talked about this too. Now, I don't know how familiar you guys are with the term hoarding. Now, hoarding is a mental illness. And, I like to talk about the psyche of people and what drives them. And the fact that we know that they're mentally ill. We know that they have and there's a new study about ADHD and hoarding going together as well. So I want to talk about that, and we're going to do a show about that. We're going to do Buster's interview tomorrow, but then the next show we'll do will probably be about the hoarding thing, because I think it's very interesting that they can link the ADHD and the hoarding and the mental illness all together. I mean, that's a new study. I didn't know about that, but that's very interesting, isn't it? I mean, it kind of makes a little bit.
I don't know if I can do tomorrow. I have to work 9 to 8 tomorrow.
Oh, okay.
So I don't know how it's going to be when I get off. I may be wiped out, and then Thursday is my boyfriend's birthday. So
exciting.
I don't know. Tomorrow and Thursday may not work for me, but I can do Friday.
Why don't I just do the Buster thing tomorrow, and we'll do our hoarding thing on Friday?
Yeah, okay. However you want to do it, babe. However works for you. I just want to kind of let you know, give you a heads up.
Yeah, because I want to have something to do tomorrow. Days we don't come live and I don't get to talk. I don't get to talk about it. It makes me sad. I just love coming on and actually.
I'll stalk you while I'm at work.
That's right. Okay, good, good. Okay, so we'll do Buster's interview tomorrow afternoon, probably about. My sister will be here. I might have to do tomorrow night anyway, because my sister will be here. I forgot. She has her doctor's appointment, eye doctor thing. And so she's on her way here now. It's about a 2-hour drive. And I don't know. I'll just have to let y'all know tomorrow.
Leslie, we'll play by ear. Yeah, we can play by ear.
Sure that I put something out there, and I will let you know. Okay? I want to make sure I don't mess you up, and so you miss. So anyway, thank you all for coming over. We really do appreciate it. I hope you enjoyed listening to what's really going on in that Murdaugh case, because it is more than meat pie. It is more than what you've been told. And I think this is going to be very interesting in the appeal. So you guys have a good afternoon.
Yeah. All right. And hug your babies.
That's right. Hug those babies. Bye, guys. I'll talk to y'all later.
Okay, bye.
Bye.